Learn more about how medical records are cherry-picked by long-term disability carriers, particularly in MS cases. It's not unusual for MS to progress to the point that a policyholder is no longer able to work and then applies for their disability insurance benefits that they purchased to provide them with financial security if they became disabled. Let me tell you the story that's found in the case of Gornia versus Aetna Life, which is a Washington state case. This case will explain the cherry picking that goes on in cases. Now, Ms. Gornia was a staff analyst for Boeing, and she was diagnosed with MS in 2007. She had 6 short-term medical leaves for MS, which were approved for the period from February of 2013 to February of 2015. She had been under the care of Dr. Reif since 2007 and had maintained a clinical practice since 1982. He conducted MS research, including clinical trials, taught medical professionals about MS, performed disability employment determinations, and was well recognized in the industry. His records documented a decline in her functionality over time, objective medical changes by MRI, and increased symptoms, including bowel and bladder issues, which are secondary to the progression of MS. Now, of course, when she applied for disability benefits, Aetna's clinical nurse looked at the records and cherry-picked those records. As a result, the claim was denied. Dr. Reif wrote a detailed letter taking apart the finding of Aetna's nurse. Aetna then had her file reviewed by a neurologist. The neurologist, the liar for hire, concluded that there was a negative neurological examination with no progressive decline. Reif wrote yet another letter taking apart Aetna's neurology's conclusions. Aetna's response was that this new material and letter from Dr. Reif did not provide clinical correlation for any specific restrictions and limitations. Obviously, that was full of you-know-what. So she filed suit in the state of Washington, and in Washington, you can't have a discretionary clause in an insurance policy. As a result, the judge can substitute their own judgment for that of carriers like Aetna, who have no intention of paying benefits, regardless of what the medical records document or the qualifications of the treating provider. Fortunately, the court found that Aetna's analysis of the claim was flawed, to say the least. It had improperly cherry-picked medical records to justify the claim's denial. The court slammed the sloppy way that Aetna handled the claim from the beginning to the end and awarded her benefits. What's the lesson learned? Well, the first lesson is that if you are in a state that prohibits discretionary clauses and your claim is denied, you've got a leg up, because the judge can use the de novo standard of review and can substitute their judgment for that of the carrier. The second lesson is that it always helps to have a detailed medical rebuttal of the liar for hire, clinical nurse, or peer-reviewed doctor to take apart their denial. What's the medical rationale for their denial? What was the basis of the opinion, if there was one? And how did their opinion correlate with the medical evidence? We always want to have the treating physician rebut the opinions of the peer review doctor, peer review nurse, or even an IME provider. So those are the 2 lessons learned. If your claim has been denied, I can help you get the disability benefits you deserve regardless of where you live in the United States. Call today at 727-894-3188 for a complimentary consultation. I look forward to helping you today.